Hello, everyone. I am Alan Candle, and welcome to our webinar on Corporate Transparency Act for Employee Stock Ownership Plans. Before we begin, I want to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We'll try to answer all questions during the webcast today, and preferably as we're going through the presentation rather than holding them off until the end. But if a fuller answer is needed, or if we run out of time, it'll be answered later by email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow with a recording of the webcast for watching and sharing. And I think that addresses a question that we just got about a colleague who wouldn't be available today. So it will be recorded and it'll be emailed to you. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's it for all the housekeeping items, so let's get started. First, I've introduced myself. Again, I'm Alan Candle. I'm a partner in the Employee Benefits and Executive Compensation Practice Group with Husch Blackwell. And I have two other of my partners here on the webinar today, and I'll let them introduce themselves.
Hi, everyone. I'm Jordan Burkamp. I'm in our Kansas City office. I'm also in our ERISA and ESOP practice group.
Hey, everyone. My name is Yufan Wong. I'm in the Denver office. I'm a corporate M&A lawyer. I also head up our CTA task force. Nice to see everyone here.
So I'm going to kind of start with giving you the punchline for what we think is the most critical issue for ESOP companies, because ESOP companies need to know whether they're subject to the reporting requirements of the CTA. Yufan is going to discuss the CTA rules generally, and Jordan and I will discuss how they apply to ESOP companies. So the applicability of the CTA to a company, or rather I should say, whether an ESOP company is a reporting company, as that term is defined in the CTA, will depend on the company's corporate structure. If the company has a simple structure in which the operating company is owned directly by the ESOP, then in most cases the ESOP-owned company will be exempt and will not be a reporting company that's subject to the CTA's reporting requirements. On the other hand, if the ESOP company has a holding company on top of the operating company with few or no employees, and the ESOP owns the shares of the holding company, generally the ESOP will own all of the shares, 100% of the shares of the holding company, then the ESOP company might not be exempt depending on the trustee. And so is the trustee an individual or is the trustee an institutional trustee? And we're going to talk about some of the details of that a little later on. So before turning the program over to Yufan, we have a polling question to get us started. And that is just to get a sense of who's on the call here. For those of you who are with ESOP companies, does your ESOP company have a holding company structure? And there are three possibilities: yes, no, and not sure.
Also, I think in order to get CLE, I think you might have to vote. So if you're not sure, just click not sure.
So it looks like people are still submitting their responses.
Yeah,
We're over 70%. So I think we'll see what the results are. So of those who responded, over a third said yes, they do have a holding company. Little less than a third said no, and little less than a third said not sure. So, Yufan, take it away.
Sure, thanks, Alan. So I'm just going to give you some background on kind of the overall background and mechanics of the CTA. And then, Alan and Jordan will kind of chime in when it relates to an ESOP. This is kind of dense, dry subject matter. So if anybody has any questions, please just type into the Q&A, and then we'll do the best job we can of answering it. The Corporate Transparency Act, or the CTA, or the Act, it's important because unlike a lot of regulations, I guess, in the US, this one specifically targets smaller companies. So, in the beginning, I had a lot of people come up to me and say, well, I have a single member LLC that just kind of holds some family, real estate. Do I need to register? And the answer is yes, unfortunately. So it's specifically targeting those smaller kind of entities in the US. And the other important thing is that it requires reporting of natural persons. So, if you have kind of a complicated holding structure, it's not just you can just report the intermediary entities and be done with it. It goes all the way up to natural persons. So just wanted to note those two things in the beginning. So the background is that this is kind of an anti-money laundering act. It was passed in 2021. It was kind of a bipartisan bill that was passed, but it was only enacted this year in 2024. So the genesis of it is that most countries, especially in the EU, whenever you form a company, they kind of require you to report on the beneficial ownership of those companies. The U.S. is one of the few kind of large, industrial economies where that's not the case, and that's mostly because, as you know, forming entities is driven. It's a state law process. So you usually don't form an entity with the federal government. You form it with the state. And each state has their own different laws, and most do not require any beneficial disclosure. There's kind of three concepts I want to call your attention to. One is reporting companies. Those are the companies that are kind of subject to this law and that require reporting. And then there's reporting on beneficial owners and company applicants. I'll get into each of those more later. Another part of the rules that are being promulgated by FinCEN is how the information is stored and who has access to it once it is stored. So a reporting company is basically any entity that you generally would think of as being kind of a corporate entity. This includes specifically corporations and LLCs, but there's also some language in the law saying that it's any other similar entity created by filing a document with the Secretary of State or similar office. So there's a little kind of confusion here. It has to be created. So for example, if you're, at least in Delaware, a general partnership is not created by a filing, but you have to kind of register it with the state. Or if you're converting an entity from, let's say, a corporation to an LLC, well, the entity is not created through that conversion. It's just merely a conversion in form. So a conversion doesn't necessarily trigger reporting requirements. The information you need to report for each reporting company is its name, address, jurisdiction information, unique identification number, which is usually your EIN, and then information about its beneficial owners and company applicants. So a beneficial owner is an individual who directly or indirectly has a 25% or more equity ownership stake or has substantial control over the company. So I just want to call your attention to a few key words here. One, individual means a natural person. So you'll never report an entity as a beneficial owner. It always has to be a natural person. Directly or indirectly means that, going back to my previous example, if you had a long chain of entities you wouldn't just report the intermediate entities, you'd report the people all the way at the top. So, depending on the structure of your companies, it could be kind of a complex legal determination of who is a beneficial owner. The other prong beyond ownership interest is substantial control. And that again is a pretty broad definition on purpose. It includes kind of the enumerated roles here, senior officers. And senior officers specifically includes your presidents, your C-suite, even your GC. The last prong I want to call your attention to is anyone who has any other form of substantial control. I think it's a very broad catch-all, and I think they included that because, let's say you were like a money launderer, right, a cartel or someone. Well, El Chapo is not going to be listed as a CEO of the cartel, right? He's going to be off in the background somewhere, but he definitely exerts substantial control over the organization. So this is meant to capture kind of formal roles of individuals in the organization. This was the definition. So as I said, it specifically calls out presidents, CFOs, CEOs, and COOs. I think it would, for example, also include the board of directors. I don't see how someone on the board doesn't, exercise this kind of control over a in the corporation context. Even if you had like a large board, right? Any one of those board members, for example, could cast a deciding vote for a major transaction. So I think any member of the board of directors would be included, and also managers of an LLC and their analogs in the partnership context. The ownership interest prong is, I think it's a little more complicated than it sounds. It's a vote or value approach. So it's 25% of the equity interest, whether they're pure economics or whether they're voting. It's a little complicated in the partnership taxation context because, for example, if you have like a waterfall in an LLC, then your economic interest in that partnership would vary depending on, let's say, a small liquidation distribution or a very large liquidation distribution. I'm talking about like preferred partners, for example, right? Like they could either get a huge part of the pie or a small part of the pie, depending on the financial performance of the partnership. So there is kind of a catch-all rule that says you have to be reported as a beneficial owner if you own 25% or more of any class or type of ownership interests. I usually like to just kind of rely on this rule unless it's pretty clear otherwise in the partnership context, just so, you'll hear me say this a lot through the presentation, there's no penalty for over-reporting. Okay.
Hey, Yufan, I'll
Sure.
color comment here 1 minute. So in especially the ESOP context, right, a form of management incentive compensation are stock appreciation rights. And stock appreciation rights are not specifically listed in the final rule, but there is what Yufan's talking about, the catch-all. And there seems to be, I haven't seen anyone take a definitive stance, and within our group even, and talking to some other attorneys, it's not clear whether or not something like a SAR, where it's a phantom equity, would constitute this 25%.
Yeah, that's a great point, Jordan. I do want to go back to the previous slide, and SARs are not included, but a number of other forms of equity interests are included specifically. And that includes the profits interest I was talking about earlier, and also convertible instruments, warrants, puts, calls, and options, except those created by a third party, right? If someone's shorting your stock, then you might not know there was an option created. That's not going to be included, but it is pretty broad. But yeah, SARs are definitely not specifically listed.
I just think
maybe I can chime in on that, because I think the reason there may not be certainty about that, or at least people haven't been willing to say with certainty whether or not SARs are included, is that FinCEN hasn't said. And
that's right.
The language of the regulation, this catch-all language, refers to any other instrument, contract, arrangement, and so forth used to establish ownership. And of course, a distinguishing feature about a SAR is that it does not establish ownership. It establishes a right that is similar, is the economic equivalent of the right of an option, or it's similar to the right of an option, because it enables the executive to receive the value of the appreciation of the company stock, but it doesn't create an actual ownership interest like an option would. And so it's not clear that SARs should be included in this catch-all.
Yeah. So the SARs are one aspect of this catch-all, this 25% or more. And then another aspect in the ESOP context, and this would be pretty rare, although I think we got one question about this, is what if someone inside the ESOP has an account balance that is 25% or more of the value of the company? And it's also not exactly clear whether that beneficial ownership within the ESOP would constitute requiring filing information on that person. Now, I don't want to get too much into the weeds here on this 25% rule, because eventually we're going to be talking about how you're exempt from filing, and that kind of makes this 25% rule somewhat moot.
Right, but looking at the two questions that I'm seeing now, one of them is, would warrants over 25% be included? I think the answer to that is yes.
Yeah, warrants, I think, is yes. Yeah, if you're a reporting company, which we'll get into in a second. Yeah.
Yufan, if I could also ask another kind of question on the ESOP context. If you have an ESOP company, let's say there's a holding company, and the ESOP doesn't own 100% of the shares of the holding company, but there's an institutional trustee. And let's say the institutional trustee has a fiduciary committee that consists of 3 or 4 people. These are the ones who make decisions as to voting the shares or whatever for the institutional trustee. Would they be treated, in your view, like the directors of a corporation, because any one of them could cast a deciding vote?
I think so. I think that's pretty analogous. I see some questions here, so I'll just go ahead and try to answer them. The first is from Jennifer Barbie. She's asking if, well, this is a question of Jordan, but I will attempt to answer it. If no one holds more than 25% of ESOP shares, there is no specific individual owners for this purpose? Question. So that's true for that purpose, but you're always going to have to list some individual as a beneficial owner, because yes, nobody owns more than 25%, but there's going to be someone who exercises substantial control. So that's
yeah, and I think in that case, again, we're kind of jumping ahead to a topic we're talking on whether or not you're a reporting company. In that case, if no one inside the ESOP has 25% or more, I think the beneficial owner you'd be reporting would be the trustee of the ESOP trust.
Right. And then Mary Josephs had a question. She asked, so warrants at over 25% would be included. And yes, 25%, if you have enough warrants to buy 25% of the company, post issuance of the equity in exchange for the warrants, then you would meet that prong and be declared a beneficial owner. Okay, I'm going to move on, unless Jordan or Alan.
No, I think good to move on now.
Okay, so there are some exemptions for beneficial owners. I won't kind of get into it too much, but it's minor children, creditors, individuals whose control derives solely from employment, but there is a carve out for that for senior officers. So, if you're, for example, a CEO or a GC and you own no shares, you would still be a beneficial owner via the substantial control prong, just by virtue of you having that role. And the information required to be reported, it's your full legal name, date of birth, address, and your unique identifying number. So this part is, where it's a little kind of intrusive, I think, right? Because you have to submit a photocopy of the document containing that unique identifying number. So most people in the U.S. are probably going to, submit your driver's license. And I'll talk about this a little later, but this law is kind of agnostic as to your citizenship. So if you have a beneficial owner in another country, they would also have to send their passport, for example, or some kind of analogous identifying information. And that's going to be stored at FinCEN. I'll cover that, the parameters around that here in a bit. So a company applicant is, and this concept only applies to individuals, to reporting companies that were formed this year or afterwards. So January 1, 2024 or afterwards. So a company applicant is basically someone, it's up to 2 people who create the entity. So in our law firm context, for example, it would be someone like a paralegal or a third-party service such as CT Corp, so an employee at CT Corp that forms the entity on our behalf. And when this kind of regulation first came out, a lot of people thought you could just name, for example, let's say like the client contact as a second applicant, right? But I think based on FinCEN's latest FAQ, it's pretty clear that it's a supervising lawyer, so probably the partner on the transaction. And this also requires similar information to be reported as for beneficial owners, that is your name, date of birth, address, and a unique identifying number. And again, this is, if your entity was created prior to this year, you do not have to report this information. One, I think, it's not required, and 2, just being practical, right? If you created an ESOP or like a company 30 years ago, you're not going to remember who that is probably. But going forward, you will have to report this information. I see a question from Danielle, might be for Jordan, but I'm going to go ahead and read it. Question is, do you think reporting the trustee is sufficient, or do you also think you need to also report the institutional trustee committee members? I'll leave that to you, Jordan or Alan.
Yeah, so the answer to that is it depends on the type of trustee, which is, again, something we're going to talk about in a little bit. If it is an individual acting as trustee, yes, I would think that is sufficient. If your trustee is an institution, that is, I think, where Alan's question come in. We need to essentially find the natural persons that are making the decisions, that have the control.
That's the case if the company is a reporting company.
That's exactly right. Yeah,
we'll talk in a little bit shortly about a situation in which a company with a holding company structure may not be a reporting company.
We'll come back to that when we talk about that in a minute.
Okay.
So if I can clarify on the company applicant, this is getting a little close to home for those of us who are lawyers in our firm. Category 2, the person who's primarily responsible for directing or controlling the filing. Let's say that we're doing an ESOP transaction, and as part of that, a new company is created. And let's say that somebody at our firm is doing this transaction. Rather than having a paralegal file the articles of incorporation with the Secretary of State's office, we outsource that to somebody else.
Mm-hmm.
The person who files the document would be that third party that it's outsourced to, but with the person who's primarily responsible for directing or controlling the filing, do you think that would be the attorney who is in our firm who was doing, or any other law firm that's doing an ESOP transaction?
Yes, I do. So I think, again, when the rules came out, right, I think it was ambiguous whether it's, because, the other argument being that, well, the attorney wouldn't be doing the work but for the client's request, right? But I think if you look at, there's an FAQ that came out earlier this year. I want to say it's FAQ E5 or E8. It specifically addresses that issue. And what it says is basically no. In that scenario, it would be the kind of senior managing attorney. The only scenario would be if the client directly contacted the third party or the paralegal and said, here, form this entity, here are the org docs. In that case, yes, but in the general, I mean, that almost rarely happens, right? That's probably doesn't happen in 99.9% of transactions. So I think in the standard course of things, it would be the partner doing it.
Hey, Yufan, I'm going to return to one question we have about a trustee. They're asking the context of this question is in who would be the beneficial owner and who needs to be reported if the company is a reporting company, right? And the question is, does it matter if it's a directed or an independent trustee? And I think that it matters on who will be reported. So if it's a directed trustee, I think this goes back to Yufan's point that the board of directors in that context are the ones directing the trustee, and so they would be reported in this context of the beneficial owner. Whereas if it's an independent or a discretionary trustee, then and it's an institution, right? Then we would likely need to look at the fiduciary committee or whatever committee is making the decisions for that company. Really the gist of it is who is the natural person making these decisions.
Okay.
And
Thanks,
just
Jordan.
to add on to that, I don't think that having the trustee be a directed trustee would make the directed trustee, not a beneficial owner for reporting purposes, if reporting is required, because the trustee, whether it's directed or independent, is the legal owner of the shares.
That's a really good question, Alan, because if it's an institutional trustee and it's a directed institutional trustee, you're only reporting natural persons. And if that institution is receiving all of their direction from the board of directors of the corporation, I guess my thought was that it would still then be those natural persons are the people you report, and not necessarily XYB Bank Trust Company as trustee. But this is an example of it's not exactly clear on who's reporting.
Right. So we have another question from Michael again. Does it make a difference if the board has 3 or 4 members or 15 members? Are they all treated equally for purposes of control? I think there's a question for you, Fan.
Yeah, I would say they're treated equally. Any of them can vote on substantial matters, and any of them could be the tiebreaker. So, okay, I'm going to move on. Oh yeah, the timing is I've kind of alluded to this before, but the timing for when the reporting has to be made is it's pretty important. So the CTA, the rules came into effect January 1st of this year, 2024. So there's kind of a trifurcation. I don't know if that's a word. So a splitting between entities created prior to that date and then after that date. So entities created prior to January 1, 2024 do not need to report until, I say here January 1, 2025. Technically, it's 11:59 on December 31st, 2024. So has to file a report sometime this year. If the entity was created on or after January 1, 2024, but prior to next year, so any entity created during this calendar year has to file within 90 days of creation. And then after January 1, 2025, until the end of time or the invalidation of this law, whichever happens first, you have to report within 30 days. So I think up until pretty recently last year, it was always going to be you have to file within 30 days. But then after some comments, FinCEN decided to give entities created this year more time to file. So hence the 90 days this year. I personally would not wait until the end of the year, just because I think something like less than 10% of entities that should file have filed so far. So there's going to be a huge, mad dash at the end of the year. I'm sure FinCEN systems will be overloaded. So I'd go ahead and try to report, not later than the fall. And then there's also kind of an obligation to update your information. So let's say you declared yourself the beneficial owner, and then you have to, your address changes. You would have to report that information within 30 days.
Yufan, your comment on not waiting necessarily to the last minute and hope that the FinCEN website works is really telling, especially this morning when I tried to go to the FinCEN website to do last minute review of their FAQs and their website was down this morning.
Okay. That sounds great. Yeah. Sorry, I have a question here from Dan. Is it a question usually? Sorry, I'm just going to read this out loud. From Danielle. Usually the administrative committee at the company have the authority to direct a directed institutional trustee. So perhaps the administrative committee would be beneficial owners as well. Maybe that's more a question for Jordan or Alan.
Yeah. So Danielle, I agree with that. And this is where it becomes really fact intensive on what is the arrangement, who has the votes, who's on the administrative committee, right? But I'm going to slightly table that because I think our next couple slides, again, are going to make that a moot point for an overwhelming majority of our ESOP companies.
I'm going to move on. Thank you. I think it might be the slide after this, Jordan. But so the good news, we might have wanted to talk about this earlier, but there are actually 23 exemptions from the CTA. Most of them concern they're either for companies that are already regulated. For example, public security issuers, your Microsofts or Teslas or whatever, publicly traded companies are exempt. That's because they're already regulated by the SEC, which requires a lot of other beneficial reporting information. A lot of kind of financial institutions, your banks, your bank holding companies, and so forth are already regulated by FINRA and therefore exempt from the CTA. There's also tax exempt entities, so forth. But the one important one, especially for this conversation, is the large operating company exemption. I think this is probably going to be by far the most popular exemption along with the subsidiary exemption. So this says that any entity that directly employs more than 20 employees filed a tax return in the previous year demonstrating more than 5 million in gross receipts. I consider that to be kind of line 1A of the form, and has an operating presence at a physical location in the US would be exempt. So kind of let me drill into that. Directly means that if you have an entity for a holding structure, for example, where you have an affiliate that employs employees that work for the main operating company, that would not satisfy that requirement. However, if you're filing as a consolidated group of companies, then each of the consolidated filees could use the $5 million prong of that. So they would be exempt if they file consolidated, as long as they satisfy the other two prongs of this test. So this is a pretty important exemption. And then, by the way, exemption means that if you're exempt, you don't need to report. You don't need to kind of report on why you're exempt or attest to it. It just means you don't need to report. Kind of an honor system here. And along with this exemption, there's another important one called the subsidiary exemption. That means that if you're, let's say you're a wholly owned subsidiary of an entity that doesn't need to report because they're a large operating company, that wholly owned or controlled subsidiary also does not need to report. So I think that's a more narrow exemption than that may sound. Even if a small shred of control is, controlled by a third party that's not exempt, right? So a common, PE structure, right? You have a GP that owns like 0.1% and then a bunch of LPs. Even if, for example, all the LPs were exempt somehow and the GP were not, I think based on the FAQs that subsidiary would not be able to avail themselves of this exemption. So
Well,
Moving
Yufan, I think
on. Yes.
it might be helpful. So I just scrolled through, I guess, took a look through our attendee list, and so a large number of our attendees that are at companies, just looking at their names and knowing who they are, they're not necessarily worried about having less than 20 employees, except if they're in the holding company structure currently, and their holding company does not have employees, right? And the second reason this is somewhat important is I literally just had an email last week with a client who has 21 employees. And so the question is, how are the employees counted for this 20 employee rule? And so the FinCEN rule says that they have to be full-time employees. And then it references, for the definition of full-time employees, it references the regulations under the Affordable Care Act. But what it does not do is reference the regulations under the Affordable Care Act for full-time exempt employees. So like when you can aggregate some part-time people to become a full-time exempt employee. And it does not have the averaging concept in the applicable large employer calculation. And FinCEN kind of punted on that in their preamble on whether or not kind of punted, they said they are not going to use an averaging concept. And so I think, Yufan, and correct me if I'm wrong, what that essentially means is if you are a company that has 21 employees and you lose someone or someone retires for whatever reason and you go down to 20, next year you'll have effectively 30 days to hire someone to get to above 21 again before you're required to report, because of that 30-day window on when reports are due.
Or to report,
or to report, or you report. Yes, that's right.
Well, I mean, so kind of a slight nuance there is, I would say that let's say you're created in 2023, right? And then you lose that 21 employee status before the end of the year. I would say you have to file before the end of the year too.
Yeah, whatever time period that it happens, I agree. Yes, the timing rule. Yes.
Right. That actually leads into a question from John Leonardo. If we haven't filed for a 2023 entity, assuming we have until the end of this year, what happens if there is a change in beneficial owners in 2024 before we file the 2023 entity? Should we file the 2023 entity? Should we file the 2023 entity then reflect the change in 30 days? So I think, I think this kind of goes to what we were talking about before. If there's a change, I wouldn't wait till the end of the year to file, but I would wait till the change has occurred this year, whatever it might be, and then file the report. That way, you've already accounted for the change and you're not having to file something within 30 days. If that's not possible, then yes, I agree with you. You would have to, like, let's say the 30 days would kind of cross the threshold between this year and next year, then I would agree. You try to file by the end of this year and then account for that change in the 30-day update. Okay. Mary Josephs asked, what is the logic of 20 employees? It seems like smaller companies would present less risk. So I actually disagree on that. I think the whole point of this is targeting, shell companies through anti-money laundering. That's why a lot of the exemptions exempt big companies, right? Companies that are otherwise have a presence that everybody knows about, for example, the public, or that are regulated by other entities. If you look at kind of the studies they've done, it's these kind of small single member LLCs that serve as, the conduits for all these crimes going on, the laundering. Because you can set up a Delaware LLC with, an LLC as an owner and so forth, and kind of hide the money laundering. So the larger you are, the more of an actual physical operating presence you have, the more likely, by FinCEN and Congress's assessment, the more likely you are to be a legitimate company and not be engaged in money laundering. Okay, moving on. Oh, I think this is an Alan or Jordan slide.
So yeah, I think this is my cue to step back in. So I said at the beginning that the analysis of whether an ESOP company is exempt from the reporting requirements depends on whether or not the ESOP company has a holding company structure. So first, we'll look at an ESOP company where the ESOP owns the operating company directly. And I want to go back to one of the exemptions that Yufan mentioned is an exemption for tax-exempt organizations. Of course, an ESOP itself is tax-exempt. However, the exemption for a tax-exempt organization under the CTA applies to an organization that's described in Section 501C of the Internal Revenue Code and is exempt from tax under Section 501. Well, an ESOP is exempt under 501, but it's described in 401A of the Internal Revenue Code, not 501C of the Internal Revenue Code. So an ESOP doesn't have an automatic exemption. Yufan had mentioned that any company that fits under regulated companies, for example, banks or broker dealers or accounting firms, those are all exempt by virtue of the nature of their business, even if they're smaller. But for most ESOP companies, again, in this structure where the ESOP owns the company directly, the question is going to be if the operating company is a large operating company. We may have some, I'm sure there are some ESOPs out there that are not large operating companies, meaning that they have 20 or fewer employees or 5 million or less in gross receipts. But most ESOP companies are larger than that, and so are going to be exempt in this simple structure where there's not a holding company. Then you get to the other kind of structure that is very common for ESOP companies, and that is that the ESOP owns a holding company and not the operating company. And typically the revenue requirement of being a large operating company is met, like Yufan mentioned a minute ago, because it will have more than $5 million of gross receipts. On the 1120 or 1120S, they'll file as a consolidated group, and so the subsidiary companies' gross receipts will be rolled up into the 1120 of the holding company or 1120S. But a holding company generally doesn't have more than 20 employees. A holding company may not have any employees at all. And so the focus is really going to be on the subsidiary exemption. Excuse me. So what this exemption says, you can read it, but I'll read it out loud just to kind of focus on the words of it, is any entity whose ownership interests are controlled or wholly owned directly or indirectly by one or more entities described in all these paragraphs. And I think the most important paragraph for our purposes is paragraph 21, which is a large operating company exception. It's interesting, FinCEN has published some FAQs that give a little more detail, and actually I'd say a little bit of a slant on this. The phrase controlled or wholly owned seems like if it's controlled, maybe not necessarily completely controlled or wholly owned, that the company would fall under the subsidiary exemption. But then FSQ says that the subsidiary's ownership interests have to be fully 100% owned or controlled by an exempt entity. This doesn't quite match the regulation, but it's FinCEN's position. It's also interesting that the statute does not say wholly owned. It says controlled or owned. And so, not that we need to get into Supreme Court jurisprudence, but the Supreme Court a couple of weeks ago just overturned a precedent, the Chevron case, that gives deference to the positions of administrative agencies. And I wonder if the addition, the requirement that's added in the regulation, and then the further requirement in the FinCEN FAQs would be upheld if this were challenged in court. I think we'll have to see about that. Something else that, on the wholly controlled part of that phrase, is that an ESOP is required to have pass-through voting for certain organic corporate events. And it's a question. I don't have an answer to this. Does that mean that an ESOP company can never be wholly controlled by the parent organization? It's a question. I don't know the answer to that. So looking at the subsidiary exemption, of course, an ESOP itself can't do anything. An ESOP is has a trust, and with any trust, the trustee acts on behalf of the trust. And this means that the trustee owns and has legal title to the shares of the trust. And so if you have a company where the shares are certificated, not just with record ownership, but with trust certificates, the certificate should say that the name of the shareholder is the name of the trustee, whoever that trustee is, as trustee of the widget company ESOP. It shouldn't just say the widget company ESOP. I think that some certificates might be worded that way, and maybe some bookkeeping entries where corporations don't issue certificates are worded that way, but that really doesn't describe the relationship, and it's probably not the best practice. Now, a trustee of an ESOP can be an individual or an institution. And we learned earlier on that an individual can't be a reporting company, and therefore it can't be exempt from being a reporting company. So if the trustee is an individual and the individual trustee owns a holding company, the holding company will not be exempt from the reporting requirements. If the trustee is an institutional trustee, then you have to determine if the trustee is exempt under one of the exemptions. And I think all of the trustees I've worked with and that I'm aware of in the ESOP space are large operating companies. And so it seems pretty clear that the subsidiary exemption should apply to a holding company if 100% of the shares are held by an ESOP and an institutional trustee is the trustee. Now,
Alan, if I may interject a couple points here, because we have a number of trustees on the call today, and make this really fine point distinction that Alan's making here, right? So the individual versus the institutional. There are trustees out there for various reasons beyond the scope of this call that may be with a large operating company. They may even have a company, right, that they themselves employ people, but they are signing as an individual person as trustee on behalf of the ESOP trust. And what Alan and we're concluding that if the holding company itself is not a large operating company and that individual as trustee then is not exempt themselves, that the holding company would be a reporting company that has to report their beneficial owners. And then one thing we probably should have talked about on the beneficial owner slide that I forgot to talk about then was that FinCEN, in their preamble to their final rule, did address employee stock ownership trustees. Some commenter asked them, hey, why don't you exempt ESOP trustees from the beneficial owners? And the response essentially was, well, the Corporate Transparency Act, as passed by Congress, has specific exemptions, and we don't have the authority to add to those exemptions. So they did it. They were asked about it, and they did address it in terms of beneficial ownership.
Thank you, Jordan. so we had, FinCEN has not stated specifically that a holding company that itself is not exempt because it has 20 or fewer employees, that is wholly owned by an ESOP that has an institutional trustee, where the institutional trustee is a large operating company. FinCEN has not specifically said that the holding company would be exempt as under the subsidiary exemption. And we asked FinCEN you can ask questions on the website to try to get FinCEN to say that in that situation, the holding company would not be a reporting company. FinCEN didn't answer. It replied back with, these are the exemptions, and didn't apply it to the specific situation that we were asking about. And so I think because of this, there may be some, I think it sees a pretty low level of uncertainty that maybe in that situation, the holding company would be a reporting company. It seems to me that that's not a reasonable reading of the regulation of what it means to be a subsidiary. The subsidiary exemption says if the shares are wholly owned or controlled by an exempt organization, then the subsidiary would be exempt and would not be a reporting company. Others may have a different.
Alan, I don't disagree. I think we're in the same camp there, right? As we've discussed. And I do want to take a minute. So FinCEN didn't answer our question. Like Alan said, Alan submitted a question asking about ESOP trustees. They didn't answer it. But what they did do in their preamble is there's a sentence that they say that the trustee of a trust or similar arrangement can exercise substantial control over a reporting company through the types of relationships outlined in this that goes on to the paragraph. And so, I mean, when you read their preamble, and like Alan said, a reasonable reading of the regulation, it seems to us to conclude that if the institution, the ESOP as an institution, is itself exempt, whether it's regulated or a large operating company, that when it owns 100% of the holding company and all its subsidiaries would then be exempt as well. But we do want to make the point that no one has definitively said that from FinCEN.
Yeah, now I think, what if the ESOP owns less than 100%? Well, you definitely would not have the subsidiary exemption. And if it's a holding company that the ESOP owns, it would have to, you would just look at that company's characteristics and not the ESOP trustee to determine if it's a reporting company or not. We have a couple of questions.
Alan, yeah, we have a difficult question that I'm going to let you answer. So we just talked about if the institutional trustee, right, is itself exempt, whether it's a large operating company or it's a regulated entity. But what if that institutional trustee is a directed trustee of the ESOP trust? So it's taking all its direction from the board of the holding company, and the holding company is not exempt. Somewhat circular there, right?
Well,
I think that
the trustee is 100. If the ESOP owns 100% of the shares, then the subsidiary exemption would apply, because the exemption applies if there's 100% control or 100% ownership.
Or ownership. That's right. Yeah.
So that's one question that Billy asked. The other question has to do with, what about a holding company with more than 20 employees and no revenue, but more than $5 million in consolidated revenue? Consolidated revenue is what counts for purposes of the greater than $5 million rule. So the other issue on this slide is, what about a real estate subsidiary? Assuming that the trustee is a large operating company, an institutional trustee, and that the holding company is exempt as a subsidiary of that institutional trustee, then any other subsidiaries that fall underneath the holding company would be exempt as well, because the subsidiary exemption applies to any companies that are directly or indirectly owned by the parent exempt company.
I think now we should, we're happy to field questions, but I think we want to give Yufan the last 5 minutes, because there is some recent updates to the Corporate Transparency Act and some other information that he's going to give.
Sure, thank you. So I just want to cover this really quickly. A FinCEN ID is, so let's say you're going to be filing a lot of these reports. Instead of reporting your information each time, you can get like it's almost like a username, right? So each time you need to make a report, you can use your FinCEN ID in lieu of you reporting your address and everything. You just have a duty to identify the information stored within the FinCEN ID. I think this is also better, not just for convenience, but this way you're not constantly sending photocopies of your driver's license or providing your address over email, which, as we all know, is not the most secure medium. So I recommend that. I know that everybody at our firm who regularly files these has their own FinCEN IDs. There is penalties are an important thing I want to talk about. Is there are civil and criminal penalties, but they're only for willful violations. So that means that you're intentionally misreporting information in order to defraud FinCEN. So the standard is pretty high, but it's still there. The only caveat to that is senior officers of a reporting company where there is a willful violation of file, even if it wasn't that particular senior officer that willfully failed to file or not report, they are strictly liable. So that's kind of an interesting wrinkle in the regs. Again, this is a new regulation. There's been no litigation regarding the substance so far. So it's hard to, it's hard to say how that'll be enforced. But if you're a senior officer, I'd be concerned about this. For my clients who, operating agreements and stuff like that, I actually put in a provision that requires all the people that would be considered beneficial owners to have to report the information to the partnership rep, basically. So something to keep in mind. There are some, FinCEN is still kind of rolling out its access rules. So one thing to note is that this isn't like a public database, right? It's you can't just go in and Control F someone you don't like and find their address, right? It's also not subject to FOIA requests. FinCEN is kind of rolling out who it's going to share access with. Right now, it's just kind of a law enforcement, your FBI's, your Homeland Securities, and then it's going to be rolled out to Treasury and regulatory agencies. And finally, it's going to be rolled out to state law enforcement agencies, and also foreign investigative bodies like your Interpol or something. They can't directly access the database, but they can make requests of FinCEN. So that's an important distinction. And then I do want to, one last thing I want to cover is there was a case that in the Northern District of Alabama where the plaintiffs, which are members of the National Small Business Association, they actually successfully challenged this law as being unconstitutional. And the district court judge did find it unconstitutional, but only with respect to the plaintiffs as of the date of the decision. So if you're one of the 600 members of the NSBA, as of March 1st, 2024, the laws are kind of they don't apply to you for this right now. It's been appealed to the 11th Circuit, and it's kind of going through that. But again, it only applies to the members of the National Small Business Association at the time of the ruling. And then one last thing I do want to cover is that we can debate on whether or not this is constitutional, but a number of states are actually adopting very similar laws for entities kind of registered to do business or created in their state. The most important one is the New York LLC Transparency Act. That is already passed. It's going to be law in 2026. And this one is kind of annoying because, one, So all these state laws so far are in addition to the to federal CTA reporting. So you got to file your federal CTA, and if you're formed, or if you're an LLC formed or registered to do business in New York, you also have to file with New York separately. One of the annoying things about this one is that unlike the federal CTA, if you're exempt, you need to file an attestation that you're exempt. And that's just kind of a growing trend right now, unfortunately. California is looking to pass a similar law. If and when Delaware does file one, that's going to be crazy. But just need to watch out for, even if the federal CTA is overturned. So I will leave the last -1 minute for questions, I guess, if anybody has any we can address right now.
Well, I say that I think we need to wrap it up because we've hit the hour mark. So if anybody has questions, feel free to reach out to any of the three of us after this. I'd like to thank everybody for joining us today, and we hope the information was helpful to you and your organization. As a reminder, the program has been approved for legal education hours. So to report your hours, click on this CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you.
Thank you, everyone.
Thanks. Feel free to reach out with any questions, by the way.